Hello everyone, I'm back to do a quick lecture on profits, license, water rights, right to lateral and subjacent support, and also zoning. Okay, so let's get started. It's going to be a quick lecture. This is just will help you for memorizing the elements for your MBEs as well as essays. And most of these I don't see often, but they might show up. You never know. I've seen them a couple times. So we have profit entitles its holder to the right to enter the Serbian estate land and remove soil or product of the land. Okay, that's the main one right there. So if you get an MBE and they're removing some type of soil or product, then we're going to look to profit. Similar to an easement, if you don't have the easement approach down, then you can go ahead and watch my easements video. I do have one of those. It may be a pertinent or engross, and I talk about what a pertinent is, and I talk about what engross is, and it terminates like an easement encramped. Okay, so these are the termination. This is the termination mnemonic for easements. You guys can go review my video for those. Let's go to license. License is the right to use the licensor's land for some specific purpose, and it is revocable at the will of the licensor. Lots of MBEs on this. It may be freely revoked. It is merely a privilege, not an interest in land. If there's oral agreements, they produce a license, not an easement. But if we're going to enter into detrimental reliance, then it is possible an oral license created an easement by estoppel, which is using detrimental reliance, and we do get some MBEs on those. Move on to water rights, drainage of surface waters. So using the use of this is an owner may use all he wants. Okay, surface waters, an owner may use all he wants. Getting rid of surface water, common enemy, owner may cast water onto neighbor's land. That is okay. The CL rule, owner has strict liability for interfering with the natural flow. Don't interfere with the natural flow, or strict liability for the owner. Reasonable use doctrine allows owner to act reasonably. So of course we have to argue reasonableness here. If we get a water rights, which I've never seen, but could be possible. Let's go to riparian rights. Riparian rights are waterfront, streams, and lakes, things like that. Reasonable use theory. For riparian rights, owner may use as much water as he reasonably needs, and the courts will consider the purpose and extent of the use, okay? Prior appropriation doctrine, California uses this, and the owner must obtain a permit to use the water, and the priority of use is determined by the permit date. So whatever date is first gets priority to use this, okay? So that's the riparian, never seen, but it is in some of our books. Groundwater. Groundwater is different. An owner may make reasonable use of groundwater drawn from his property. Just reasonable use on that one. Right to lateral and subjacent support. I've seen essays and I've seen MBEs on this. Every landowner has a right to receive necessary physical support from adjacent soil, which is lateral support, and underlying soil, which is the subjacent support. Lateral support right is absolute. Natural state. Landowner is strictly liable if his excavation causes adjacent land to subside while in a natural state. I've seen MBEs on this where they're building a wall next door and the caves in, makes some part of their property cave in, and is he going to be responsible for that? Improvements, that also goes to improvements. Natural state means, is it natural for it to actually cave in, or is it just because of the land underneath was extremely just bad and it's the natural state of it? Now, if they make improvements on the land, like building a wall, landowner is strictly liable for its excavation only if it is shown the land would have collapsed in its natural state. So if it would have collapsed in its natural state, then the landowner is definitely liable, is strictly liable. If not, then you're going to use negligence. Then landowner may be liable through negligence, okay? We've got a lot of MBEs and I've seen essays on this. Subjacent support arises when something is removed from below the surface of the land. The owner of the surface land has a right to not have the surface subside, which includes the buildings as well as the natural state. That's subjacent. Zoning, let's move on to zoning. Zoning is very important. This comes out on MBEs as well as essays, and you need to know how it works for the MBEs. Purpose is, it's based out of the 10th Amendment, general welfare, to protect the general welfare of the citizens. Standards must be reasonable, not arbitrary, and have substantial relation to the public benefits that we mentioned above, whatever their general welfare is. Types of zoning ordinances, there's cumulative and non-cumulative ordinances. You want to talk about those? Non-cumulative and cumulative. So cumulative, that means, let's do the non-cumulative. So let's get the, we do have to get the definition for that one. Cumulative creates a hierarchy of uses of land. So a hierarchy, whoever at the top. Land zone for a particular use may be used for the stated purpose or for any higher use. An example, a house could be built in an industrial zone, but a factory could not be built in a residential zone, okay? Non-cumulative, land may only be used for the purpose for which it is zoned. Non-cumulative can only be used for the purpose of which it is zoned. Cumulative is the hierarchy use of the land, okay? A little different. Variance. Variance is a waiver. A waiver from a zoning regulation must show unnecessary hardship due to the unique features of the property or practical difficulty, and harm to neighboring areas will also be considered. So we're going to argue these for our defendant for variance, okay, if they want to do a waiver on this. Non-conforming use. Now, non-conforming use of the property was allowed before the zoning ordinance came in, okay? But now it's no longer permitted under the new zoning laws. Now, some jurisdictions allow it to continue. Some jurisdictions provide for termination by reasonable amortization, which means that they're going to give them a time frame to actually be able to comply with the new zoning ordinance, but they need to. Some say allow them just to continue because it was already happening before the new zoning ordinance came into effect. And there's a lot of MBEs on that where someone has a shoe shop before the ordinance came in effect, and they come in and do a new zoning on it, and their defense could be a non-conforming use. It's already been there. Okay, and based on both jurisdictions, you need to write up both here. Improvements of or rebuilding. So any change or improvements must comply with the new zoning. So people who already know have the new zoning and they're going to do an improvement or a change in their building must comply to the new zoning. If structure is destroyed, let's say it's destroyed or burned down, the rebuilt building must comply with the new zoning regulations also. Okay, this is non-conforming use and improvements and rebuilding. Taking, I had to put the takings clause on here because usually if zoning it comes up on your essay, you may also have to give rise to a the takings clause, Fifth Amendment, but you're gonna have to see this constitutional law lecture for this. That's where we discuss takings. Okay, that's pretty much it for all of these. Now, you might see some of these: a profit, a license, water, support, and zoning. I've seen a lot of license on MBEs and essays, and I've seen maybe 1 or 2 water, but support and zoning I have seen on essays and MBEs. So that's the lecture. Good luck on the bar exam, and you can view my other lectures. I've done the entire real property now. So I've actually done a lecture for each real property section that is tested as on the bar exam. Land acquisition issues, I have that one in there. It's adverse possession. Land sale contracts, I have that one done. Conveyance by deed, I did a lecture on that. Estates and land, the freehold estates, present interest and future interest, I did a actual video on that. I've done joint ownership, which is the 3 types of tenancy: joint tenancy, tenancy in common, tenancy by the entirety. I've done landlord and tenant. And now I've done the land uses. I've done the land uses too: easements, real covenants, equitable servitudes, and I finished it up with this lecture. This lecture has a profit, license, water, and zoning. Okay, thank you, and see you my next video.